Okay, it's 5:33, so I'm going to go ahead and get started. Welcome, everyone, and thank you for joining us. It's, I guess, one upside of our current situation is that we didn't have to drag you down to City Hall at night to attend this meeting, so that's good. I want to start off by, I see a lot of familiar faces, but if you are a newly appointed member, could you please just raise your hand so we can see in the screen? So we've got John Suter, Steve Shane, and friend. and let's see who else. Anybody else new?
Yeah, you can say
Maureen, okay.
I'm Cheryl Bolton.
Oh, Cheryl, that's right. I should have remembered.
Housing Committee, and I'm married.
Okay.
Or he's married to me. I don't know.
There you go. All right, well, welcome everybody. I'm going to go ahead and share my screen. We have a little PowerPoint for you so we keep track of what we're talking about and what we're up to. You have arrived at the Community Advisory Body Orientation Workshop for new and returning members. And with me tonight and also presenting is going to be our City Attorney, Michael Gina. And also with us tonight is the person you deal a lot with, the friendly voice on the end of the phone or on the other side of the email, Deputy City Clerk Lorraine Leon. And with that, we'll get started. I do want to, the city manager, Christine Daniels, sends her apologies. She actually had a scheduling conflict for tonight. Otherwise, she would be joining us. She is actually virtually attending the mayor's conference with our new mayor, Diane Martinez. Otherwise, she would have definitely been here. So tonight, we will cover these topics that you see on your slide. The City of Emeryville's form of government, the Ralph M. Brown Act, which is more commonly called the Open and Public Meetings Act, the Public Records Act, and then the Emeryville Rules of Procedure for local boards, commissions, and committees. Those are the rules for the conduct of meetings that are set by the City Council for the committees and commissions. And then we'll save a little time at the end for questions. What I'd like to do too, as we go through the sections, if you don't mind, is let the section of the presentation be presented, and then we'll save time at the end of each section for your questions rather than taking questions throughout the presentation. Unless you have a burning question that you just can't wait to ask, we'll definitely call for questions at the end of each section. So Emeryville is, for the most part, a general law city. And what a general law city is a city that is bound by the state's laws, even for its municipal affairs. So we cite here the government codes that authorize general law cities like us to be governed by a city council of 5 members and a city clerk such as myself, a city treasurer, police chief, a fire chief, and then any other subordinate officers or employees that are needed. And the government code also allows us or authorizes us to have the city manager form of government. And if I could ask if anybody needs to be muted during the presentation part so we don't get any extraneous noise. There is a tiny part of us that is a charter city. And the charter that we have establishes that the city has power over its own municipal affairs when it comes to municipal revenue, including taxation and assessment, and a system for real property transfer tax. But in all other respects, the powers of the city are, as I said, general law and are governed by the general laws of the state of California. This charter over taxation and assessment was approved. It had to go to the ballot, and it was approved by the voters in November of 2014. As I mentioned, our form of government in Emeryville is the council manager form of government. And so the city council, which consists, as we said, of the 5 council members, they are elected at large by the public for 4-year staggered terms. So 2 are elected in one election in the even years, and then the next election there's 3. So you never have 5 newbies on there. There's always people that have been elected and have served at least a couple of years, so that you never get an all new council. So they establish the city's policy direction, and then it's the city manager's job to take their direction and carry it out. Of all the employees for the city, only the city manager and the city attorney are appointed by the council. All the remaining staff are appointed and supervised by the city manager. So that's what we mean when we say a council manager form of government. Oops. So this is our city council. As we said, there are 5 members elected at large, which means each of them serve the entire city. They are not confined to districts. Many cities, as you may have heard, have in the last couple of years gone to district appointments. That would be quite difficult to carry out in a city the size of Emeryville. But there could come a time in the future when we'd be required to do that. But currently our members each serve at large, serving the entire population of the city. And their terms are for 4 years. We hold our elections in even numbered years, as I said, with 3 council members elected in one cycle, and then the following election, the remaining 2 council members, and they alternate like that. The only real requirements to be a city council member is that you must be what we call an elector of the city. In other words, you must be registered to vote, and you must have been a resident of the city for the year prior to the election. But other than that, there are no real requirements to run for city council. And then as far as the mayor and vice mayor, the council it just chooses from among its own members, and for those 2 positions, and they serve for 1 year in that role. And so on December 1st, we had what we call the city council reorganization, and the council elected Diane Martinez to be the mayor and Scott Donahue as vice mayor. These are just close-up pictures of your city council. Mayor Martinez and Vice Mayor Donahue's terms will expire in 2022. And council members Bowders, Medina, and Pats were all just in an interesting kind of a change. They were not on the ballot for election in November because there was no one running against them, and they all wished to run again. But since they were uncontested, they didn't have to go to a vote of the people. They could just appoint, the council appointed them to their seats. So that's why you may have wondered when you voted in November, you didn't see a city council race in the city of Emeryville. And that's because nobody was running against them, so they were just able to be appointed, which is very unusual. The city is broken down into several departments to handle all the various business. The first 6 there are what we call our administrative departments. We serve internal customers, each other. So there's the city manager, the city attorney, the city clerk, finance department, our information technology, and then human resources are all administrative departments. And then we have community development, which houses planning and building and economic development. We have public works, which does all of our streets and signaling and many other projects. Community services is parks and recreation and our child development center. And then for public safety, we have a police department. And as you may know, years ago, we went from having an internal Emeryville fire department to contracting for our fire services with Alameda County. So that's our public safety sector. And now I'm going to turn you over to our city attorney, Michael Gina, and he's going to present to you about the Ralph M. Brown Act, or our Open Meetings Act. Michael?
All right. Thank you, Sherry. So could everybody hear me? We get a thumbs up on that?
Yes.
All right, thank you.
Let me know when you want me to advance your slide.
Okay, thanks, will do. I'm Michael Gina. I'm the city attorney, and first, let me thank all of you who are serving on the various boards and commissions and committees of the city. I'd like to thank you for your service. The work of the committee is really important in allowing the city council to do their work in terms of forming policy and making decisions. I recognize that it is time out of your schedules to attend committee and commission meetings. And so I'd like to extend my thanks to you for your service. My role here is in the city attorney's office is to, in relation to the committees and commissions, is to really help you through some of the state laws regarding, in this case, the Brown Act, or the state's open meetings law, and the Public Records Act. And so this will be a really brief overview. If there are questions about the Brown Act or the Public Records Act that we don't necessarily cover here, I can always be reached, and the city clerk's office can provide you my contact information. The city attorney's office has also done a little roadshow to some of the commissions and committees and done a deeper dive into the Brown Act as well. And so if the committee ever wanted additional training, we can provide that too. But the purpose of this is to give you a really broad brush overview of what the Brown Act is and what the Public Records Act is, so that when you hear these terms, you're aware of them, you're able to spot issues. So next slide, please. So the Brown Act, what is it? The Brown Act is the state's open meeting law. And it provides in part that all meetings of a legislative body shall be open in public. The intent of the act is that public agencies like the city and like the various commissions and committees and boards that you serve on are doing the work of the public. And therefore, the public should be able to understand and know what that business is, what's going to happen, when it's going to happen, what are you going to talk about. So the state has adopted the set of rules in the government code collectively called the Brown Act that says that all of the work of a public agency, such as the city at the city council level, but also the various advisory committees and bodies that you serve on, have to be taken in an open and public manner, and one that allows the public the right to observe what happens at those meetings and to participate in them. You'll see in the second bullet, I underline the word meetings and legislative body. Those are terms of art in the Brown Act, which I'll get into in a little bit more detail in my presentation. So next slide, please. As I said, the intent of the act is that the public's business will be conducted in the public setting so that the public has the ability to participate. Again, the public has the ability to know when you're going to meet, what you're going to talk about, and then the right to participate. And the public participates by hearing the deliberation of what you're talking about and what you may be voting on before the decision actually is made, so that the public has the ability to talk to committee members and commission members in an attempt to give you their perspective before you actually make a final decision and vote. Next slide, please. So briefly, what it means in terms of how the committee and commission does its day-to-day work. Agendas. The committee, before the committee meets, the committee has to post an agenda. The agenda is put together by usually it is the chair in conjunction with the with staff in putting together the agenda for the meeting. That agenda must be posted for a regular meeting 72 hours in advance of the meeting, for a special meeting 24 hours in advance. There has to be an agenda title, which provides a brief description of what is going to be considered or acted upon. And only those things that are on the agenda can generally be considered at any given meeting. The meetings have to be open to the public so anybody can attend. and listen to what is being deliberated upon and what is being acted upon. The public also must be given the opportunity to speak at meetings, and they have to be given. There are two opportunities when the public is allowed to speak. If you look at your agendas, whether it be for your committee and commission or the city council, you will see that there is a section near the beginning of your agenda that's called public comment. And so that's an opportunity for any member of the public to speak, to address the committee and talk to and raise any issue about anything within the committee's purview. The second opportunity for the public to address the committee is before you take any action on an item. And so you'll have, for each item, the chair usually will ask if there are any comments from the public before a vote is taken. Let's see, and then generally speaking, that last bullet, generally speaking, the meetings have to be held within the city. And that's in order to, prevent a legislative body from hightailing it out of town and having a secret meeting in a place that's inaccessible to the residents. Now, during COVID times, we're all working, remotely, and nobody's coming to City Hall. So, this last bullet, that the meetings have to be held within the city limits, there is a temporary exception to that that was promulgated by the governor's executive order, but that only temporarily suspends that requirement during the pandemic emergency. Once that executive order is lifted, the default rule that the meetings have to be held within the city limits will reapply. Next slide, please. All right, so this is a little graphic about how I sometimes think of the Brown Act. One of the things I often hear in my practice is, the Brown Act is a drag. It takes a lot of time. It doesn't make for an efficient meeting. It is slow and cumbersome. And my response to that is absolutely yes, because the Brown Act is more like a big ocean liner rather than the fast speedboat. And by a big ocean liner, I mean that it is designed to carry a lot of people at the same time to the same destination. And it is a process that is supposed to allow for as many people as possible to participate. And that process takes a lot of time. But the point is, the whole point of the Brown Act is that you want to allow for as much public participation as possible. And so the state legislature has decided that the ability for public participation in a governmental meeting is more important than speed and efficiency. So is the Brown Act, does the Brown Act make for more process? Absolutely. But on the other hand, the process instills instills public trust in the process, right? The public understands what they're going to speak about, what the committee is going to speak about, and trust that there is an opportunity for them to address the committee and the decision makers. Next slide, please.
Oops, went to sleep on me.
All right, so I said at the beginning of this section that there are some key terms. One of them is a legislative body. So what is a legislative body of a local agency? Your committees and commissions, those are legislative bodies, right? Those are bodies that are created by the council that have that will go on until the council has decided that they are no longer needed and would take a vote to rescind or do away with that particular committee or commission. But until then, those bodies will continue in existence and meet on an ongoing basis. What is not a legislative body for Brown Act purposes is an ad hoc committee. So an ad hoc committee is a committee that is created by your committee or commission that is made up of less than a majority of the total body membership. And it's created for a specific issue for a limited duration of time. So if you have a 5-member committee, right, you can have a majority of that are 3 people, right? So you can't have, a ad hoc committee has to be less than the majority. So you can have up to 2 people on a ad hoc committee. And that committee would be formed to study a specific issue or study a specific topic and then report back to the committee. The ad hoc committee should not only have a focused reason for its existence, but also within a limited time frame. The longer that an ad hoc committee goes on, the more and more it looks like a standing committee. That may present Brown Act problems. But an ad hoc committee is not a legislative body, and it doesn't have to comply with the Brown Act requirements of posting an agenda, having public comment, having a defined place and time of meeting. Next slide, please. What is a meeting? So under the Brown Act, there are 2 types of meetings. There is a regular meeting and a special meeting. A regular meeting is a meeting that is set by the city council as to when your committee or commission meets. So, at the beginning of each, either at the creation of the committee or at usually around this time, the committee will establish the regular meeting schedule for your particular body. They will also establish not only the time, but the place of the meeting as well. So sometimes usually it's at City Hall, sometimes it may be at another offsite location. But the point is that the City Council is communicating to the world that, hey, every 4th Tuesday of the month at 5:30 at City Hall, this particular committee will meet so that the public knows that that will happen. So that is a regular meeting. A special meeting is any other meeting of your committee or commission that does not happen at that regular place, time, or date. The importance of the distinction between a regular and a special meeting is the notice requirements. So as I stated in my earlier slide, a regular meeting needs 72 hours. The agenda for that needs to be published 72 hours in advance. For a special meeting, the agenda has to be posted only 24 hours in advance. A meeting is further defined in the Brown Act as a gathering of the majority of your members to hear, discuss, deliberate, or take any action on anything within your subject matter jurisdiction. So the hearing, discussing, deliberating part is important because it also includes items where no action is taken. So, oftentimes in your agenda, you will have a section that is discussion items, and there are sections that are called action items. So even if your committee is not taking any action, but is just receiving information or receiving a report, that is an item that needs to be put on your agenda as well. The Brown Act allows for technological conferencing as well. Again, during COVID times, we're all doing technological conferencing. But during non-COVID times, there are certain limits as to the conditions under which people can use remote call-in to participate in a meeting. I won't go into those details here. Your committee secretary and the city clerk will be able to give you more of those details, but I just wanted to make you aware of that. Next slide, please. Okay, so what are not meetings under the Brown Act, or what are exceptions to the Brown Act requirements for meetings? So individual contacts. So if you as a committee member talk to one other person on your committee, that is not a meeting of your committee. However, you have to be careful, because if you have multiple meetings with more than one other committee member, you may be close to having what's called a serial meeting, which is a violation of the Brown Act. And I will talk about serial meetings in just another minute or so. Conferences. So if you and a majority of your other committee members are attending a conference, that is not a meeting of your legislative body. As long as you do not talk about the business of your committee at that conference, right? But if you all happen to be at a committee to get at a conference together to receive training, and there is a majority of your body present, the fact that the majority of your body is present in and of itself does not make a Brown Act meeting, and that does not, your presence does not violate the Brown Act. It's only when a majority of you start talking about business of your committee outside of an agendized meeting that you run into problems. So similarly, social community events, social events, if a majority of you are at one of those types of meetings or events, that is not a Brown Act meeting of your body, as long as you are not talking about the business of your committee. And then again, the last two bullets there, meetings of other legislative bodies or meetings of another committee. If a majority of you are at those meetings, that itself is not a Brown Act violation either. Next slide, please. So these are when there could be violations of the Brown Act. Again, coming back to this idea that the business of your committee should be conducted at an agendized, noticed meeting where the public has the opportunity to participate in the meeting, knows what you're going to talk about, has the ability to address your body, and has the ability to listen to what your deliberation is like, right? And if you have an action item before you that you're going to be voting on, you as committee members should not be, you as committee members should be approaching each of those action items with an open mind, because you haven't received all the information that you need in order to vote on an item until you've heard all of the information that staff has to provide, all the public comment that is provided on any particular item, and the deliberation amongst the rest of your colleagues as to the pros and cons of any particular action. Until you've had all that information, you may not have all of the information you need in order to have a fully, a full stack of information that you would need to make a vote or to do a vote. So in that regard, any decision-making that is happening outside of that noticed public meeting is a violation of the Brown Act. So what are some examples? The first example is a serial meeting. And that's where you have a series of communications among committee members outside of a noticed public meeting, where there is a collective consensus of what to do once you do get into a committee meeting. So let me give you an example. You've got, committee member Smith has coffee with committee member Jones, right? And they start talking about a project that is before their committee, right? And again, as I said earlier, the meeting of individual contacts is not necessarily a Brown Act violation, right? And let's assume for purposes of this example that you've got a 5-member committee, right? So you've got 2 committee members that are speaking to each other. One of them says, this is how I think I'm going to vote on the upcoming agenda item. I'm going to vote yes for it. Smith says yes. Jones says, I think you're right. I'm going to vote yes too, right? So you've got 2 committee members that have decided what they're going to do. Again, in and of itself, not a Brown Act violation yet. However, after the Smith and Jones meeting, right, Jones then goes and talks to Robinson, right, and says, hey, committee member Robinson, I just had a meeting with committee member Smith, and we decided that we are going to vote yes on the action item that's on next week's agenda. What do you think? And committee member Robinson says, you know what? I think that's a good idea. I agree with you folks. So now out of a 5-member body, right, you've got 3 of you that have decided what you're going to do or how you're going to vote on something outside of a noticed public meeting, right? The public has not had the opportunity to hear that deliberation among those 3 committee members and comment on that and potentially provide their input on it before those 3 members have made their decision. So that is a meeting of a majority of that committee that has happened outside of the noticed public meeting without the ability for the public to participate, and that would be a violation of the Brown Act. Another way that a serial meeting can occur is what's called a hub and spoke model. So what I just described is sort of this linear approach. Another way, the hub and spoke model is when you have the committee members that are the various spokes of the wheel, but you have a central hub that has that information and is transmitting it out to everybody else. So the example is, committee member Smith talks to the committee secretary on staff, right? Who says, hey, staff person, I think I'm going to vote yes on next week's agenda item. The staff person then goes and has a separate meeting with committee member Jones, right? Different committee member, and says, hey, committee member Jones, I just spoke to committee member Smith and he's going to vote yes on the agenda item. And committee member Smith says, well, that sounds like a good idea. If Jones is going to do it, I'm going to do it too, right? And then the committee member, committee secretary then talks to a 3rd member, right? And communicates the same information to the 3rd committee member. And that 3rd committee member agrees and says he's going to do the same thing, right? So you've now had 3 members that have not necessarily spoken to each other, but the central denominator in that was the committee secretary who was relaying information. So that's a problem as well. The point of that example is you don't know where your communications with your individual committee members are going to go. And while a one-to-one communication is not necessarily a violation in and of itself, you don't know where that communication will lead after you've left that conversation. So the best advice is that you should wait until the notice public hearing to make your decision on how you're going to vote on a particular item on your agenda. And again, you need all that information that would be presented at a committee meeting before you make that informed vote. A serial meeting can also happen via email or text as well. So you don't have to have an in-person meeting to have a common consensus of what people are going to do. And so an email or text exchange may also lead to a collective concurrence outside of the notice public meeting and maybe a violation of the Brown Act that way. Retreats, gatherings, again, as I said earlier, the fact that a majority of you have met at a retreat or workshop is not a violation of the Brown Act. But once you start talking amongst yourselves at that retreat or workshop about business of the committee that you serve on, that is a violation of the Brown Act because you're talking about committee business outside of a noticed public meeting. Be aware of social media as well. So if you have, let's say, a Facebook account, right, and you identify yourself as a committee member and you are saying, I'm going to vote, I support the proposal to do X, which is within the subject matter jurisdiction of your committee or commission, or you start liking somebody else's Facebook post on the same topic, that may be construed as a collective concurrence as well. All right, next slide, please.
Okay, and Michael, I'll do a little time check. We have about 5 minutes left for this section.
Okay, thank you. All right, so agendas, public participation. As I noted before, the agendas for before anything that the committee is going to talk about has to be put on an agenda. Anything that is not on your agenda cannot be discussed at that meeting. There's some special exceptions for emergencies that generally do not happen at the committee level. But generally, anything that is on your agenda, you can discuss. If it's not on your agenda, then you cannot discuss it at that particular meeting, but you can ask the rest of your committee to put that on a future agenda. I think I provided the notice requirements of special meetings, so let's move on to the next slide. As I said, if it's not on the agenda for your particular meeting, you cannot talk about it. During the public comment section, generally that's the time for the public to address the committee. There should not really be a back and forth with the public once they provide comment, unless you want to ask them for some clarification about what their comment might be if it's germane to your discussion. As I mentioned before, the public has the right to attend all of your meetings and hear your deliberations and participate by providing public comment. Any records and recordings of your committee meeting are also subject to disclosure under the Public Records Act, which I'll get to in just a second. Next slide, please. Closed session. The City Council goes into closed session. Sometimes it's called executive sessions, where what they discuss is not open to the public to observe and comment on. Advisory bodies, such as the ones that you serve on, are not allowed under your rules of procedure to go into closed session. So all of the entirety of your agenda and all of your work is done in an open session where the public can participate. Next slide, please. All right.
So I told you that we would have a question section, a question and answer period at the end of each section, and then I promptly blew right through the one that I was supposed to offer you. So if people have questions, now would be the time to ask about any of the things I talked about in terms of our form of government in Emeryville, and then any questions on what Michael's just presented about the Brown Act and the open meetings law. And I see we have, oops. John, I see John Suter has his hand raised. Please unmute yourself and go ahead.
My question is to Michael. It's something that came up today in a committee meeting, and it's relative to contacting other members of the committee via email. And it sounds like you are indicating how many people are involved, or if you agree on something, but even then, you made it sound like even then it would have to be more than just the two of you. So I really would just, rather than going into that kind of mechanics, I wanted to know, are there any topics that are quote unquote forbidden? Example is our interconnection via email is either to answer a question that we felt was, let's say, abusing the time available for the rest of the committee's processes, or to help a committee member on another committee with, with comments and suggestions or helpful guidance. So are either one of those not recommended?
Let me take the second part of your question first. So if you are discussing If the question is giving advice to if you and somebody else are on the same committee and that other person serves on a different committee as well, right?
Right.
And they're asking you advice about, process or even like even something that is on the agenda of that different committee, right? You don't serve on that different committee, right? So you are not a member of this committee out here. So you can talk to that member about the subject matter jurisdiction in this committee out here without violating the Brown Act, right? The issue about Brown Act violation is only within the subject matter of your own committee.
Okay, so then the first question would apply to that, not the second one. So, and that is where somebody is wanting to understand something and one person is willing to, let's say, quote unquote, talk offline, which means with an email. Is that not, suggested?
Yeah, so correct. My recommendation is that you don't engage in offline conversations with your with your fellow committee members on matters that are within the subject matter of your committee. And the reason for that is whether it be by email or voice or a telephone call or text, while a one-to-one communication is okay, you don't know how many other communications may happen after that, right? And all of you together collectively, if there are more conversations than beyond that one-to-one conversation, all of you collectively then may have violated the Brown Act. The other thing I wanted to emphasize is that the Brown Act, violations of the Brown Act, they govern your action as committee members, right? So it is restricting the activity that you as committee members are having in terms of your communication. That's important to realize. But to answer your question, my recommendation, and it's conservative advice, but it helps keep the process intact, is to not engage in offline communications with other committee members on items that are within the subject matter jurisdiction of your committee.
Okay, well, then it definitely applies to your steamship version versus speedboat. It basically says the priority is public knowledge and we should make it public to the rest of our committee. We should never really have each other's emails. We should not deal with business outside of the committee, even though it may drag a topic on for a couple of months.
Yeah, I mean, again, it's not efficient, but it allows for the best public process.
Okay. You answered my question. Thank you.
Sharon Wilshire?
Sure. So I don't know, maybe that answered my question too, but on our committee, we do have subcommittees that are, that take care of a specific thing, and there's a time framework, et cetera. It's just and so, I mean, I've had the occasion where maybe a subcommittee member has gotten in touch with me just to get some more information about a certain topic. And it has nothing to do with, let's see, I don't know that any of us have ever said, I'm going to vote, what our vote might be, but just calling to get more information about something. And then they're going to, because they're trying to do some research for their subcommittee. And I don't know, it's difficult. I mean, many of us are friends with other people on the committee, et cetera. So you're saying we shouldn't even talk to anybody with more information about a topic, not about, let's just say it's about murals or,
Yeah,
I'm also a public art consultant, so,
Right, and I hear you. There is, unfortunately, I can't give you a bright line rule, right? That applies, I can't draw a line for you and say on this side of it, you're okay. And on that side of it, you are not okay. It is very fact specific and it's very circumstantial. And it also depends on, you know, again, your one-to-one communication is okay. And from your perspective, that's fine. And it is, right? It's what happens when additional communications are happening that do not involve you, right? That collectively there is a discussion of business outside of your meeting. And you could only control that one conversation you're having at the time, right? And so again, my advice is really conservative, but you know, my job is also to protect you collectively, the committees collectively, and protect the process collectively. So I will give conservative advice. It's not, you know, I did say, right, and I will say that a one-to-one communication is okay. It's only when you start, when those collective meetings are happening, maybe with or without your knowledge, that there are potential Brown Act problems.
So does that apply to the, I mean, and how is that, let's see. So does that come back as an admonition for the entire committee? I'm just thinking, I mean, or is it on the individual, like, I mean, because.
Sure. So in the worst case, I didn't get into it in this presentation, but there are penalties for Brown Act violations. In the worst case scenario, if there are ongoing knowing violations by a committee member, that committee member may be subject to criminal penalties, right, by the DA. That's very extreme. It's never happened in Emeryville to my knowledge, but I mean, that's as far as it can go. Oftentimes what will happen is if there is an issue that is raised and there was a Brown Act violation, then the committee may have to redo their work and if there were decisions that were made outside of a notice public meeting, then they affected what the committee has done in a public meeting, then the committee may have to redo it again, right? And that may be frustrating for the committee because you're having to kind of start from you know, you're going to have to take a step backwards in order to go forward again. That is a possibility.
Michael, if I could interject something that Sharon's question jogged in my mind. It's not always as brazen as somebody indicating, I'm going to go vote yes or no on something. And this is where blogs and websites and things can come into play. It's even indicating or telegraphing your position on a project by language that you use, like, I can't believe how stupid that project is. For example, that, you know, you might say something that's not necessarily come right out and say how you would vote on something, but by the language that you might use, you could indicate what it might eventually be. So that's another reason to be especially careful about what you might be posting about things.
After you've made a decision though, I'm just going to put this out there, and you're walking back to your car, then it's okay to say, I can't believe how stupid that project was. I mean, it's over. It's over.
You don't know if it's ever going to come back on the agenda.
I won't do it, but I'm just saying that, you know, a vote's already happened, so, okay.
Charlie Bryant?
Hi, I just want to pick up on what Sharon was talking about a little bit. She talked about subcommittees, and of course, Sharon is the chair of the Public Art Committee. The Public Art Committee often has selection committees or other kinds of committees that are a subset of their members, or even including other members. And those, I believe, would be considered ad hoc committees because they only exist for a short period of time for a very specific purpose. And when they're done with their business, then they cease to exist. So my understanding is that those would not be covered by the Brown Act. Of course, they should avoid talking to a majority of the full membership of the Public Art Committee. But as long as they follow, you know, the rules and don't talk to other folks, they can exist without necessarily having to be bound by Brown Act rules. Is that correct?
That's correct. An ad hoc committee is not subject to the Brown Act rules. So they do not have to post an agenda. They do not have to meet at a particular place and time. And the public is not invited to those meetings, right? And so they can meet at any point and discuss the business of their subcommittee without the restrictions of public participation and agenda posting that we spent time talking about.
Okay, unless there's any other quick questions, I'm going to move us along so we don't run out of time. Oh, John?
I just wanted to say, it sounds like though the ad hoc committee would be required to report to the committee itself as to what they discovered, decided, or whatever. And that way, people doing emails or face-to-faces could, let's say, even relieve themselves of the liabilities by reporting what they talked about to the committee itself.
We always, yes, absolutely. We wait to hear what our subcommittees, whether it's research or a recommendation, but it still has to come to the committee for discussion and any further action that would come from that.
Okay, let's move on to our next section, California Public Records Act, and that's going to be Michael again.
All right, thank you. I'll go through this set of slides pretty quickly. Next slide, please. Okay, the Public Records Act is a body of law in our state government code that promotes disclosure of public conduct or public operations to the public. So the idea is that a public agency should be doing its business so that the public has the opportunity to understand what is happening with the conduct of the people's business. And so the idea is that records by a public agency should be made available to the public to inspect and to read. Next slide, please. As I said, the Public Records Act allows the public two rights of access. One is the right to inspect public records, and the other is the right of the public to obtain copies of those records. The Public Records Act is not only designed to allow the public to review the records that agencies create, that public agencies create, but it also gives the public the ability to understand how their agency is working, and again builds confidence that the agency is doing what it should be doing, right? In terms of the time frame to inspect records, there's a very short time frame. So once the city has received a Public Records Act request, it generally has 10 days to respond to the requester as to whether or not the city will comply with the request, or whether the city will withhold some or all of the documents. What this means for you as committee members is that it's possible that, so I said that the city has 10 days to respond once it receives a Public Records Act request. What does it mean for the city to receive a Public Records Act request? That may indicate that one way that the city may receive a Public Records Act request is if a member of the public gives you, a committee member, a request, right? And says, you may get an email, you may get a text, you may get a request, a verbal request from a member of the public saying, hey, committee member Smith, I would like to see all of the minutes of your committee for the last year. That is a Public Records Act request. And because the city only has 10 days from when that request was made, what we would ask is if you as a committee member receive a request for what may even sound like public records, please contact your committee, please contact somebody on staff as soon as possible and relay that information to them so that we can respond appropriately. So your main contact is usually your committee secretary, but it could also be the city clerk's office or somebody else from staff who may be attending your meeting. But please, if you receive what you think might be a Public Records Act request, please go ahead and submit that to staff so that we can, so that staff can respond in a timely manner. Next slide, please. I do want to spend some time talking about public records and personal technology. So my first bullet here is a case that went to the California Supreme Court in 2016. It involved the city of San Jose. The issue here is what happens if you are using your personal technology, whether it's your phone, your personal email address, for conducting city business, for conducting committee business, right? Are those records that are on your personal phone but related to committee business, are those records subject to disclosure under the Public Records Act? In the city of San Jose case, a Public Records Act request was made to certain electeds of the city of San Jose, as well as employees, about records on city business that may have been on personal technology, either phones and or personal email addresses. And the California Supreme Court said, yes, those are public records. The fact that the records were about city business, but were on personal technology, either personal email devices or personal phones, did not change the fact that they were public records that were subject to disclosure. That's because the Public Records Act has a strong presumption that records relating to public business are public records that should be disclosed. So what does that mean? That means that any records that are created on your personal technology, email, texts, calendars, phone logs, possibly even social media posts, that relate to your official duties as a committee member may be subject to the Public Records Act. If a request for those records are made. So the advice is, right, the city does not issue you a city issued phone for your work on the committee. And we do not issue you a city issued email address. My advice is that if you haven't already, create an email address that you use only for your committee business, right? A Gmail address, right, which is free, and just use that for your city business. A separate calendar for your city business, and be aware of any emails or texts that you create relating to your committee business. Be aware that they may be subject to Public Records Act requests. So beware of what you write or what you electronically write. And I would really advise you about about thinking about that text or that post or that email, and don't write anything that you wouldn't want to see on the Jumbotron of a city council meeting, right? Or the Jumbotron of a courtroom, because those are subject to potential disclosure if asked. Next slide, please.
I think that's your last slide on this topic. So I'll open it up to any questions on the Public Records Act that we may have. Just raise your hand up if you have one, your actual hand. Okay, I'm not seeing any. So we can move on to the next topic. Thank you, Michael. Good job. Now we're going back to me. Get here. Okay, I'm going to talk to you a little bit about the rules of procedure for local boards, commissions, and committees. So the rules of procedure for committees is kind of a mimic document of the rules of procedure that the city council follows itself. And they have the authority to apply rules. The council has the authority to apply rules also to all of its commissions, committees, and boards. And these rules have to be followed. It mostly has to do with the conduct of your meetings. There's only two groups, the Planning Commission and the Housing Advisory and Appeals Board, that are not affected by the rules I'm speaking of tonight. They have their own set of rules, but they're essentially very much similar. So all of the legislative bodies are governed by rules. In Emeryville, we have a few different types of advisory bodies. The City Council has a set of committees that are comprised of 2 council members and then staff, and they talk about issues in sort of more in detail and focus, and then report back to the full council, and these are called City Council committees. You can see them listed there. Then, as I mentioned, Planning Commission and Housing Advisory and Appeals Board, they are established by ordinance and are not set up by the council per se, and they're not subject to the rules we're talking about here. And then there are the community advisory committees, which each of you sits as a member of. That's Bicycle Pedestrian, Budget Advisory, Commission on Aging, Economic Development Advisory, the Housing Committee, Parks and Rec Committee, and the Public Art Committee. Sometimes there's some confusion about the role and what the definition of advisory is. So we like to say that community advisory committees are a structured way for community members such as yourself to give your time to share your perspective and to study issues at a committee level, and then develop recommendations which would go as feedback to the city council when it's discussing an initiative. And it gives us sort of a small focused interested group the opportunity to talk about these issues and then make recommendations back to the council, which they then fold into all of the things they're considering when they make their decisions. So these recommendations are forwarded to the council. They'll be included in staff reports by staff members. And then those recommendations are only approved if a majority vote of the council says so. Any of you that are new have just gone through this process. So points 1 and 2 on this are pretty obvious, but number 3 speaks to incumbents. And there are many of you here who have served and have repeatedly applied. And then any of you that are new that are going to re-up when your term is up will be interested to know that even if you are an incumbent, when the time comes for the annual appointments to the committees and commissions, if your term is up, you still have to submit a new application. You don't need to go through and add all the blah, 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 answer all the questions unless your information has changed, but you do need to submit an application. We've had the unfortunate situation where an incumbent assumed that they were just going to be put into the hat to be considered. And despite our friendly reminders, they didn't reply to us and we didn't know, and then they missed being appointed. So don't let that happen to you. If you are an incumbent and you are interested in being reappointed, please do submit an online application. Many of the committees and commissions have designations, and these were developed when the committees were first conceived so that we'd have good representation from all segments of our population. So we have business representatives, labor representatives, nonprofit, and then various categories of residents and community members. And you can see those all listed here. Well, one thing of note is we do have, for some committees, we have a designation of a resident in the 94608 area code. So that would comprise, in some cases, people who actually live in Oakland, which could be surprising, but because of the way our borders kind of run together, we do have a couple of places where we allow that. Training and orientation, that's where you are tonight. So for the annual appointments, we do a yearly orientation where we bring as many people together as we can. For members who are appointed off cycle, who fill an unscheduled vacancy when somebody resigns before their term is up, we usually just do a informal orientation with their committee staff liaison after they assume office. And then after that, they can get caught up with the annual training. So again, we're talking about the rules of procedure for your committees and for the conduct of your meetings. These rules speak to public meetings, which Michael has talked about, and the need for those to be public. that we have to have our regular meetings on specific dates and times. They talk about needing to have a quorum for a meeting. So you have to have a majority of the membership before you can have a meeting. If you don't end up with a quorum at your meeting, the only action that can be taken is to cancel the meeting. So it's very important. And we'll talk later about the importance of attendance. And the reason for that is because of this quorum issue. You don't want to wait a month for a meeting and have important items on the agenda and then not reach a quorum because people are absent and then you can't attend to the business. So this is an important issue and one of your responsibilities. Then it just goes down with different conduct at the meeting, the right of the floor, the rules of order. The city manager attends many but not all of the community advisory meetings. The presiding officer is typically the chair. However, if the chair is absent, that role would go to the vice chair. If both the vice chair and the chair are absent, the remaining members of the committee would pick somebody, short straw kind of thing. And that person would be what we call the presiding officer. So they would run the meeting, call for the votes and that sort of thing. This last bullet, we hope this never happens. It occasionally would happen at a council meeting, but the presiding officer has the authority to clear the room if things get out of hand or there's a willful disruption of the meeting. But as I said, that is not likely to happen in a committee meeting. So we have our order and purpose of agenda, and Michael talked about a lot of these topics during his Brown Act meeting, but just to go a little more deeply into the purpose of the agenda. The whole reason we have an agenda and the reason we require you all to stick to the topics published on that agenda is because the public has a right to know what is going to be discussed at any public meeting. They're going to read that agenda and based on the words that are written there, decide whether or not they're going to attend and participate in the discussion of whatever an item of interest might be to them. If we fail in describing what we're going to be discussing on an agenda and somebody looks at that description and says, I don't need to go to this meeting, there's nothing on here I'm interested in, that's our failure because we need to make it clear to the public what's going to be discussed. So it's very important how those items are worded. There's a particular order that we try to have our agendas in, and that's listed in the rules. It's just for consistency across committees so people know what to expect and what to look for. We have our staff that prepares the agenda, and then Lorraine in my office is in charge of getting it posted and both physically and electronically. We have physical posting locations where people without access to computers can actually see a paper copy of the agenda. There are 3 of those throughout the city. And then of course, all of them are posted on our website and a newsflash goes out to people who have subscribed. There's a place on every committee agenda for what we call future item requests. And a lot of times committee members are not clear on how do I, committee member, get an item on an agenda for discussion. It says in the rules that an item can be added to a future agenda only if a majority of the committee members decide that they need majority support for an item to be added. And that item would be added to a future agenda. You don't talk about it at the same meeting where you get permission to have it on. Then you're going to run afoul of the Brown Act that we talked about. So there's a place, as I said, towards the bottom of the agenda where members can bring up future agenda items. It's not a time to discuss the merits of that item or why you think it should be talked about. You just, as simply as you can, describe what the item is. If there's consensus on the committee that could be added, then it can be agendized on a future meeting, and staff can provide guidance about what the timing might be to do that. You're allowed sometimes there's reasons to hear items out of order and you're allowed to do that. And then we are required, we record our meetings and we do audio recordings of committee meetings, and those along with the minutes of those meetings are required to be posted for public access. As Michael discussed before, citizens have rights to address the advisory body. And so any member of the public that's attending that meeting has 2 opportunities. They have the open public comment section, and then there should be a public comment allowed for each agenda item. We also accept written communications, And anybody can submit written communications that are relevant to agenda items, and those should be distributed among the members. And if they are received after the publication of the agenda, they can be brought into the meeting later. I think I mentioned this earlier, but it's good to point out that the rules that you operate by are amended or adopted by the city council, not by the committees themselves. So there's one set of rules. The committees and commissions are the council's committees and commissions, and then that means they get to write the rules. So we just at the council's December 1st council meeting did a lot of annual business. And one of the things we did was to update both the city council's rules of procedure as well as your committee and commission rules of procedure. Most of the changes were just cleanup, grammar, syntax, that kind of thing. But there are a few that I want to bring to your attention. We talked earlier about attendance and the importance of that as it relates to seating a quorum at your meeting so you can conduct your business. And a lot of questions come up every year about attendance. So the rules are, and have been for a few years now, that you're expected to attend every regular or special meeting scheduled during the year. And we're calculating that year on the same year basis as your terms. So your terms run from a July 1st through June 30th for however many years. So that's the same year term that we're going to use for your attendance. So if the member is going to be absent, you have to notify somebody, hopefully the chair or the city staff person, minimum 24 hours in advance of the meeting start. The reason this is important is because if we are going to run into a quorum issue, we'd like to be able to notify the remaining committee members so they don't show up to a meeting that can't be held. So as much advance notice, if you know you're going to be absent, would be appreciated. So you're allowed to be absent because each of the committees have a different number of times they meet. We decided to just do a percentage basis rather than saying you're allowed to miss X number of meetings. It's just a percentage of the total meetings that would be scheduled during that term year. So it's 33%. Now, you know, obviously, if we have 10 meetings a year, 33% might not come out to an even number. So we round up, you know, in those cases. But the idea is that there aren't excused or unexcused absences. It's just a flat percentage that's applied. And so we do take roll at the meetings, as you probably, or maybe the committee secretary has been doing it quietly, but we do take roll. And when you are one meeting from having exceeded the number of allowable absences, you'll be notified that you're on the brink. And that notification will come from me in a very nice letter that you'll get via email. And we'll warn you that you're in danger of being terminated. And then upon the very next absence, should it occur, you will be automatically terminated. It doesn't go to the council. They don't ask, they let us make this decision. They don't ask to weigh in on whether somebody's missed too many meetings or not. They give us that responsibility. So again, we're not trying to play hardball with anybody, but it's just out of courtesy to your other members so that they're not having meetings canceled due to lack of a quorum. And it's just part of when you decide to apply for one of these seats, it's part of your responsibility to attend the meetings. So that's it on attendance. A couple of other changes. We added in something. Occasionally, we will change the status of a meeting from a regular meeting to a special meeting. There can be a few different reasons for doing this. But in the case when we do that, when it's just to change the time or the location of the date of a meeting, and we convert it from regular to special, all of the items on that agenda, including approval of minutes and other things, can just shift to that now special meeting. So you don't lose anything by having to do that. We prefer and recommend that people keep to their regular meeting schedules because that's what people expect and it's better for the public. But in the rare instance that you do have to change from a regular to a special, that's an update to those rules on that. And then I just added a little blurb here, and I already went over it a little bit, that communications that are received after the agenda has already been published and posted may be included as late correspondence, and it can be provided separately to the members in advance of the meeting if there's time, or at the meeting with copies provided for the public. I meant to say when I started talking about the rules, and Michael already touched on it, these rules are the ones that are in effect, COVID or not COVID. Anything that changes some of these things, and as I read through it, I realize this is not what we're doing right now, but any governor's orders are layered over the top of this and would be removed once the orders are rescinded, and we'll go back to what our regular rules are. So that's just to clarify that. This happened a few years ago, and I didn't add it. I added it to the council rules, but this is just a cleanup. It's the requirement, and you may have noticed that it may feel odd to you to have to do a verbal out loud roll call vote. This is based on some legislation that was enacted a few years ago, and we have to, whether it's in person or virtual, the vote has to be taken by verbal out loud roll call. So that was just added. We, a few years ago, changed, committees used to have to spend a lot of time working on a work plan. And we got a lot of feedback that they were spending so much time creating this work plan that they never got any work done. So we took that requirement away. And instead what we do is every year we have the committees come to a council meeting. We set a special joint meeting, and as many of the members of the committee come as are available and report to the council on their accomplishments from the past year and the goals and objectives for the coming year. And you just elect somebody from among your members to speak to the council, and it's a nice time to have a little FaceTime interaction with the council and to kind of talk up your work and let them know what you've accomplished and what you've set your mind to for the upcoming year. And we align the timing of that. It's generally within the first part of a calendar year. We align the timing so that what you report can inform the council's consideration of its own goals and priorities and the budget. And that is the name of that tune. Does anybody have any questions about what we just talked about or anything? I'll go to Steve Shane. Please unmute.
Hi, I am on the Commission on Aging and Cheryl is on the Housing Committee. Is there a technical difference between a commission and a committee?
Michael, I'm going to throw that to you. I've had that question my whole life.
No, there isn't. It is a naming convention, but operationally, all of the Brown Act rules, the Public Records Act rules, the local the rules of procedure that Sherry just outlined, they all apply equally, whether your body is called a committee or a commission.
Thank you. Sharon, did I see your hand?
Yeah, no, I just had, just to clarify, so public comment at an advisory committee meeting is a little bit different than at a council meeting in that it can be something on the agenda as opposed to, usually isn't the council meeting, don't you say public comment on items not on the agenda?
Oh, well, there are two sections. So at the beginning of the agenda at a council meeting, there's open public comment.
Okay.
And that can be for anything and also for consent calendar. You have a similar open public comment on your committee agenda, but then later on when there are action items to be discussed, there's a public comment for each of those items as well.
Mm-hmm.
Did I see another hand? Charlie? And then Celeste?
I just wanted to make a comment on the question about the commission title. I've wondered that myself. There is a distinction with the planning commission. The planning commission is, you'll notice that they're not here today. And as Sherry said, they have their own separate rules. Planning commissions throughout California are required by state law. Every city has to have one. Sometimes the city council fills the role of the planning commission, but everybody is supposed to have one. And they actually make decisions that are often final decisions that don't go to the city council on development projects. So that is one commission that is a little it is called a commission and it's different from the advisory committees. So just wanted to clarify that point.
Okay, thanks. Celeste, unmute. There you
Okay,
go.
Can you hear me? Okay.
Yes,
On the agenda topic, at some point, I believe you said that the agenda is prepared by the committee chairperson and staff. But then on the rules of procedures, it lists 5 ways that an item can be actually put on the agenda, and none of that includes the chairperson or the staff. So could you explain the difference between which applies where? It lists they can be put only by a majority of the committee, a majority of the city council, the city attorney, city manager, and
city attorney, did you say? And yeah, well,
Yeah.
I'll start and then I'm going to throw it to Michael. Yes,
Yeah.
what's in the rules of procedure is the correct way, the 4 or 5 different options. And I think I did catch that you said that, Michael, but I think you misspoke.
Yeah, I did, and I have to apologize. What I was quoting from was actually from memory of an earlier version of your committee rules and procedure, which have since been superseded by what is currently in place, and that what Sherry went over this evening. So yes, I did misspeak about the role of the committee chair in putting together the agenda. So I apologize for that.
okay.
Any
So
other,
the
sorry.
the committee members actually have to do that at the end of each meeting. That's required as part of the meeting. Okay.
Correct.
And then this other was a little bit picky, and hopefully nobody will ever miss this many meetings that it makes a difference. But I think the rules say that if it's in between whole numbers, you round to the nearest whole number, not you round up.
The nearest up, yes, you round up.
No, it's not, no, but what I read, maybe I'll leave it on the slide, it says you round to the nearest whole number, which might be rounding down.
Oh, good point. Yeah, it should say round up, and that is the practice, to round up. So if it comes out to 3.37, we'd round up to 4.
Okay, great. Thank you
Yeah.
for clarifying.
Thank you. Do I see any other hands? Otherwise, I can get you out of here 5 minutes early. Okay, well, I just would like to thank everybody so much. Typically the last couple of years, we've done a giving thanks event for our members of our committees and commissions, and hopefully many of you have attended and enjoyed those. Of course, this year, with everything that's going on, we weren't able to have that, but hopefully in November of 2021, we'll be able to have that event again. It's a lot of fun and we get good attendance and there's good food. And it's just our little tiny way of saying thank you for everything you do. But again, thank you for coming tonight. Michael, do you have any wrap-up comments?
I'll echo your thanks to the committee and commission members for attending tonight. We threw a lot of information out at you tonight, and while we don't expect you to remember all of it, our hope is that we introduce you to concepts and ideas and issue spotting, so that if you have questions about them, you can contact your committee secretary or anybody else on staff. Our information is here, and you can ask us those questions. But we wanted to introduce these really important concepts to you so that you're aware of them, and as you're doing your work. And again, I repeat my offer. If any of your committees are hoping for additional training on Brown Act or Public Records Act, please let my office know, and we'd be happy to take that roadshow to you as well.
Before I let you guys go, I want to embarrass our Deputy City Clerk, Lorraine, who does so much of the work and produces all the products that you see. And this is Lorraine up here with the teal headphones on. So I wanted you all to be able to see her and appreciate her for all the work she does. All right.
Thank you.
Thank you, everybody.
Very thorough.
Right. Good night, everybody. Thank you all for coming.